For years, property owners in Citrus Springs have faced demands, fines, and lien threats from the Citrus Springs Civic Association, a Florida not-for-profit corporation. But recently, one homeowner decided to fight back. Edward Peckin has taken decisive legal and administrative action to expose what allegedly appears to be a massive overreach of authority by the CSCA, and the consequences for those involved could be severe. It started on March 9, 2026, when Peckin sent a formal demand letter to the CSCA Board of Directors. He laid out the legal facts. The CSCA is a voluntary civic association, not a mandatory homeowners association under Florida Chapter 720. It has no statutory authority to impose fines, fees, permits, or regulatory requirements on private property. The original 1970 deed restrictions never authorized fines, permit fees, lien authority, or a permit system. And under Florida's Marketable Record Title Act, Chapter 712, those restrictions were allegedly extinguished decades ago. Peckin demanded the CSCA immediately cease all fines, fees, enforcement threats, and the publication of what he alleges are invalid 2018 deed restrictions. When the CSCA failed to provide any legal justification for their actions, responding only with a single phone call, Peckin escalated. On April 1st, he filed a formal request demanding the production of all association records from the past year. He demanded every violation notice, every fine notice, every lien threat letter, all hearing records, all internal policies on fines and liens, any legal opinion the CSCA relies upon to claim enforcement authority, and all attorney communications regarding enforcement. He warned that failure to produce these records would be treated as evidence that the CSCA is acting without legal authority. The situation reached a critical point on April 21st when Peckin sent a comprehensive letter to Citrus County Sheriff David E. Vincent requesting a formal criminal investigation into the CSCA's alleged pattern of conduct. Peckin cited multiple Florida statutes that may possibly be implicated. These include Florida Statute 817.034, scheme to defraud, for allegedly using an invalid document to systemically solicit money. Florida Statute 817.535 and 713.31, fraudulent liens, for allegedly threatening to record liens that are known to be invalid. Section 713.31 is a third-degree felony. Florida Statute 83605, extortion, for allegedly threatening homeowners with fines and liens without lawful authority in order to obtain money. And Florida Statutes 831.01 and 831.02, false instrument filing, for allegedly recording a document known to be legally void. Additionally, Peckin cited Florida's Deceptive and Unfair Trade Practices Act, Section 501.204, for allegedly demanding payments based on non-existent authority. In his letter to the sheriff, Peckin also highlighted a glaring discrepancy. The CSCA claims to represent and govern the entire 34,000-lot subdivision of Citrus Springs, yet their actual membership is estimated at fewer than 200 people. Meanwhile, a community petition calling for the abolition of the CSCA has already gathered over 270 signatures, more than the association's entire estimated membership. This raises serious questions about CSCA's repeated claims of community-wide authority, particularly when those claims are used to justify the alleged solicitation of money and the issuance of threats. The individuals directing these alleged actions are the current officers and directors of the Citrus Springs Civic Association, confirmed by the Florida Division of Corporations. They are President and Registered Agent Robert B. Childers, Jr., Vice President Salvatore Candela, Secretary Laureen Pastor, Treasurer Ruth Smith, and Directors Joe Parker, Eddie Stout, Lorraine Miller, William Lamb, and Amanda Coker. It is important to note that these individuals may possibly be held personally liable for any alleged illegal activity. Under Florida Statute 617.0834, the immunity normally afforded to not-for-profit directors does not extend to actions taken in bad faith with malicious purpose or in violation of criminal law. Beyond criminal exposure, property owners who have allegedly been subjected to unauthorized fines, permits, fees, or lien threats may possibly have significant civil recourse. Every dollar allegedly collected without legal authority may be recoverable through a claim of unjust enrichment. Florida's Deceptive and Unfair Trade Practices Act, Section 501.204, possibly allows victims to recover actual damages and attorneys' fees for allegedly deceptive conduct. If a lien is actually recorded against a property, the owner may possibly have a claim for slander of title, and courts may possibly issue declaratory and injunctive relief. A court order declaring the deed restrictions extinguished and permanently stopping the CSCA from any further enforcement. Perhaps the most significantly, the alleged pattern of conduct described here may possibly rise to the level of racketeering under both Florida and federal RICO statutes. Florida's Racketeer Influenced and Corrupt Organizations Act, sections 895.01 through 895.06, does not require organized crime connections. It applies to any organization that allegedly conducts its affairs through a pattern of racketeering activity involving at least two predicate acts. Here, every allegedly unauthorized fee collected may possibly constitute theft under Florida Statute 812.014. Every lien threat letter may possibly constitute extortion under Section 836.05, and every use of the allegedly invalid 2018 restrictions may possibly constitute fraud under Section 817.034. That is potentially dozens to hundreds of predicate acts. A Florida RICO conviction is a first-degree felony carrying up to 30 years in prison, civil treble damages, meaning 3 times the actual damages, and forfeiture of all assets derived from the alleged scheme. The alleged conduct may also possibly implicate federal law because property transactions in Citrus Springs involve federally regulated mortgage lending and title insurance. A federal nexus may possibly exist as well. Every certified mail letter allegedly sent to a homeowner threatening a lien or demanding an unauthorized fee may possibly constitute a separate act of mail fraud under 18 U.S.C. Section 1341. Every email or electronic posting of the allegedly invalid 2018 restrictions may possibly constitute wire fraud under 18 U.S.C. Section 1343. And threatening to place a lien on someone's property to coerce payment without lawful authority may possibly constitute Hobbs Act extortion under 18 U.S.C. Section 1951. Each of these federal offenses carries up to 20 years in federal prison per count. This is where you come in. We need to know if this alleged pattern of conduct is continuing. Have any of the named board members or the CSCA allegedly continued to extract funds, permit fees, or fines from you? Have you received violation notices? Have you been threatened with a lien on your property? Have you actually had a lien placed on your property? Your story matters. The more homeowners who come forward, the stronger the case that this may possibly constitute an ongoing pattern of alleged racketeering activity. If you have been targeted, forced to pay for permits, charged fines, or threatened with a lien by the Citrus Springs Civic Association, please PM me on Facebook to tell your story. Your information is vital to protecting the property rights of every homeowner in Citrus Springs. Also join our private group to stay updated as this situation continues to develop. Reach out today. Your voice could make all the difference. Don't forget to like, subscribe, and share. Join the private group to get the receipts and private training. Yes, we will teach you the methods used to expose these criminals and to hold them accountable. Hit the support button on my profile and bring your questions.